All rise. Report to the District Court for County of Washington, Oxford, Michigan, is now back in session. The Honorable Judge Simpson to preside.
You may be seated. No, we're not going to do that. Court does call the case of Cross Street Apartments versus Hannah Schumacher.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Cross Street Apartments.
Your name?
Hannah Schumacher.
All right. And folks, where are we on this case?
Your Honor, if the court recalls, we had a first hearing on this over Zoom, and Ms. Schumacher raised an issue with trash collection at her apartment. And I've had a chance to talk to her and talk to my client, so I thought I'd give the court a brief update as to what the issue is.
All right.
And how we're hoping to proceed. The problem is that these are second floor apartments in a two-story building, and the building's lot line is the building's perimeter. So there's no place to put external trash cans. Historically, there have been trash cans on the sidewalk. That's been the way it has been for years and years and years. Recently, the city of Ypsilanti's code compliance people have been ticketing and refusing to allow the trash cans there. There's no place else to put them.
So the city of Ypsi's been ticketing
the owner and tenants for having trash cans on the sidewalk. The problem is we can't put it inside the building. This is one of those buildings where you open up the door, there's a vestibule big enough for the door swing, and then there's a staircase going up to the apartments. So we can't put it inside. There's no place off street to put it because my client doesn't own any place off street. So I think Ms. Schumacher is very reasonably saying, I don't want to drive 45 minutes to my parents' house to get rid of my trash. And I don't have a problem with her escrowing the rent. I'm getting up to speed on this now. What I want to do now is go back, read the city's ordinance and talk to them about this problem and try to find a resolution. So I think the best thing to do would be to kick this back a couple weeks to give me an opportunity to sit and talk to the city and see if we can't find a solution that works for the city, for my client, and for Ms. Schumacher, who absolutely should have a way to get rid of her trash on site.
What do you want to tell me? Thank you, counsel, for that.
I mean, I agree with pushing it back until the issue gets.
So that is very strange to me because I don't think in all the years I've been doing this that not having a place to put your trash has ever been an issue.
New one for me too.
I just have not heard of that. And when you were telling me at the first hearing, I'm thinking to myself, okay, what's this lady talking about? Thank you for getting that clarified because I wasn't sure when you were saying about the trash issue, and then we got the documents, and I'm still trying to. I'm like I don't understand. Like you just have no other place to put it.
Right.
So what have you been doing?
I've been driving it 45 miles one way to my parents' house to dispose of it properly.
That's not acceptable.
Bless your heart. Okay. Yeah, that's not. Are there other buildings around that?
And that's actually another part of the problem, is that there's another apartment building that my client doesn't own next door, and their tenants also tend to be putting things into any receptacles we have on the sidewalk. And so, you know, did they have the same issue, you think, or?
I'm
not sure about that. It's too early for me to know that.
Gotcha.
But, you know, from my standpoint, Your Honor, I totally understand where Ms. Schumacher's coming from. My client has been diligently trying to resolve the problem, but they haven't involved me. And as you know, attorneys have some other tools that maybe the manager doesn't have. So I'm hoping to sit down and see if I can't work a resolution of this.
And just one other question. So they've been ticketing the owner for the trash that's outside.
So, for example, Jimmy John's is a tenant downstairs in the building, and they've historically had their trash cans outside for years and years. And now code compliance is saying you can't. So my client got a $200 ticket for Jimmy John's trash cans sitting outside.
Because Jimmy John's is a tenant of your client.
Correct.
Right.
My client represents the owner.
So, okay. I'm just going to ask this question out loud. I don't expect an answer because you probably, neither one of you probably know. How do you allow a restaurant to open without having looked at whether or not they have the ability to dispose of things? But you would have done that because that's the way they were doing it.
Well, so there's two answers. First of all, what Jimmy John's is doing now is they're keeping the trash cans inside and then putting it out around the collection times. But again, I mean, this building is an older building. I mean, it probably predates the code. My position is these are grandfathered uses because it's been done like this since the beginning of time. But saying that and having code compliance agree with me, there's a long path to walk between here and there.
Oh, have you dealt with the city?
No, I'm sure this is going to be fun.
Much longer walk than you probably are.
We're going to find out.
Just going to say that. How much time do you think would be?
I'd like to kick it a couple weeks and then come back by Zoom. I don't want the Schumacher to have to come forward on these things because I don't think we have any factual disagreement between us. We're not going to need a trial. We're just going to need to find a solution.
Okay. And I'm just saying, if for whatever reason you don't get to where you need to be, if somehow or another you interplead the city, then I could foresee a settlement conference with you representing your client as Schumacher in the city. Because that's right. She should not have to be doing that.
No, not at all.
All right. So I have 7th, 14th, 21st. Well, let's be right before Thanksgiving. So which would be better for you, man? Why don't we?
I'm sorry, what was the date?
The 7th, the 14th, and the 21st.
Of November.
If you watch more football, you'd be able to follow right along. Anyway, go ahead.
The 14th.
14th would be.
Or is there a later date?
I have the 21st.
That's fine, Your Honor. I don't expect the city to be moving at the speed of lightning either. So,
your expectations will probably be well, never mind. I'll adjourn this to November 21st, 2025 at
3 p.m.
At 3 p.m. That's an in-person hearing. However, what I will do is I will allow the parties to appear via Zoom given the circumstances.
Appreciate it very much, Your Honor.
All right. Anything else, Ms. Schumacher?
There will be no judgment.
Ms. Schumacher, I do a lot of these hearings. Okay. Right now, don't you even worry about that. I think the ultimate issue is to try to figure out how to solve this problem for you. All right. I mean, certainly for the landlord, but really solve the problem for you. You shouldn't have to be doing what you're doing.
Just to give Ms. Schumacher a little bit of comfort on that issue, she's been very reasonable to work with. She's putting her money in escrow. I don't need an order for escrow. She's going to give me the information on that. And just so you understand, the most likely outcome, if we work this out, would be something called a conditional dismissal. And that would provide that you would then pay the rent because you're satisfied with the situation and the case is dismissed. So I don't see, based on what I know now, any point at which I'm going to ask the judge to enter a judgment against you. I mean, things could change, but I don't see.
And now knowing what I know, even if he asks.
Get it.
All right. Okay. Ms. Schumacher, thank you. You have a great weekend.
Thank you.
Yes, he is.
Okay. What?
He has one more, I guess I should say, in case you have.
What are you telling me?
Call the next one, we'll see if Mr. Rudy puts his better.
Well, you know what? I passed one. Pleasant Lake. Is that council's?
No, that's not.
I didn't think so. So he has one. Okay, I get it. Just whole staff's been out of control. Linden Park Apartments versus Keith Young.
Good afternoon, Your Honor. Norman Woody appearing on behalf of the plaintiff, Linden Park Apartments.
Keith Young?
Yeah.
Pardon?
No.
All right. Counsel, if you'd like to take a default, raise your right hand. solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
All right, go ahead, sir.
Your Honor, the following testimony is given on information believed formed after a reasonable inquiry into the facts of this case. There's currently rent to retain in the amount of $5,378.40 through today. Court costs in this matter are $159.15. Total amount to retain, $5,537.55. To the best, we did not ask for a money judgment in this case. To the best of my knowledge, the defendant is neither a minor, an incompetent, or in the military service, and Linden Park has kept the property suitable for use as a residential dwelling, if I may approach.
Yeah.
Thank you, sir.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Thank you, Your Honor.
All right, thank you, sir.
Have a great weekend.
You do the same. Willow Ridge Apartments versus Kumar Canadian. Give a second.
Good afternoon, Your Honor, City Judge. On behalf of plaintiff.
The defendant present, Canadian,
Not checked it.
not checked in. This is their motion, I think.
Correct. Your Honor, they had indicated that they were going to pay by today. They have not. At this time, we're requesting the writ just to be signed.
All right. I will grant that, them not appearing. I have it in my file, Mr. Katz, and I've signed that.
Okay, thank you.
All right.
Your Honor, I think the escrow was released last week. Is that correct?
That's what I have. Let me just check one thing. I do not have, well, I do have it closed out. So yes,
Okay.
it was
perfect.
sent. All right.
Okay, great. Thank you
All
very
right.
much, Your Honor. Have a good weekend.
Thank you. You too, sir.
Bye-bye.
Patrick Becker versus Daniel Wolf. Cynthia Wolf and Aaron Wolf.
Good afternoon, Your Honor, Patrick Becker.
All right. Your name?
Daniel Wolf.
All right. And folks, where are we on this case?
We had an agreement to mutually terminate and dismiss the case if they had vacated the property by today. And
Yes.
Unfortunately, I stopped by the property and that's not happening. So I was going to show up and ask for a default judgment against the two defendants who didn't show, and then the ability to try to work something out with Daniel Wolf.
Sir?
We are moving out tomorrow morning. We have a mover scheduled at 9 o'clock. We tried getting them for today, couldn't do it.
A mover?
I'm sorry?
You tried to get a mover
Yes.
and are they busy on Halloween? I don't know. Is that a thing? It might be. All right. Okay. So you're going to move
Tomorrow morning, 9 o'clock is when the movers will be there.
to move out. Okay. You were requesting was a default as to the two non-appearing parties.
Correct.
And then you did not want me to issue a judgment as against, hearing, because you said you were going to try to work to the act.
Yeah. So
Well, tell me what you guys are trying to do, because
yeah. So what happened was rent started becoming late for a few months, and we had a group meeting in early September where I had agreed to again mutually terminate and not charge them any money if they just moved out by the end of the month. They explained to me they were having logistical issues and finding a place to live, and I understood that. The property does have a detached garage. It's about 2,000 square feet, so it's large. And I told them, hey, put all your stuff in that garage. You can find a place to go. From what I understand, they're downsizing. Unfortunately, throughout the month of September, they really made no effort to move and didn't go anywhere. They also did not pay rent. I had to file with the court. In October, we went through the same thing. I told them the same thing, that they could have the exact same options if they paid rent. They did actually pay some back rent, which is great. Currently, there's an outstanding balance of $4,921.40. Unfortunately, I don't have a lot of faith that they do have movers scheduled. If Mr. Wolf could show me that they have something, or more importantly, they have a lease signed and they're moving somewhere, I think I'd be more comfortable.
Oh, he's holding something.
Please. And I'd be happy to show you the mover schedule on my phone.
Fantastic.
Oh, hold on.
I did not bring
Just
the
hold
phone.
on. You're good.
So
You have a new lease
Yes,
that starts what?
tomorrow.
Tomorrow. Got it.
Got it. So I'm very, very, very good with that. So I guess what I would ask for is a judgment for the outstanding $4,921.40. I'm not going to worry about next month's rent. They can have tomorrow for free. And I'd be super happy.
And I would argue that, Your Honor,
Pardon?
Mr. Becker has a deposit of $5,700 from us. Of that $5,700, there is rent owing in the amount of $3,900. But he can take from that security deposit, there's a delta of $1,800.
All right, I got you. Can I ask you a question now?
Sure.
You used the word delta. I understand why you, well, I don't understand. What did you do for a living?
Engineer.
Yeah, okay. That's why. All right. I mean, I understood what you meant, and I'm just like, all right.
Sorry.
Okay. So, and they're out tomorrow morning. You were going to give that free. Here's what. You got a security deposit, right? That would cover this amount? Is that,
It would.
it would? Okay, why don't I do this? And what I'm going to do is I'm going to decline to issue the judgment. I'm going to put this out 1 week.
Fair.
If they move, that's fine. And then if not, you can, if they move, then you can do the inspection, determine what's owed. If the security deposit is going to cover it, then I don't have to issue a judgment against them. You take the security deposit, delta and all, I guess. I don't know. Okay, I'm using it wrong. I'm a lawyer, didn't become an engineer because lawyers are never that exact. But oddly, my son is going to be an engineer, which is just like, well, yeah, well, my brother was. So I get where he gets it from, but it's like they're too on point. All right, so that's I think the way I'd like to handle it. Do it that way. Give him a chance to move out. I believe him that they can't get somebody today.
Sure.
For whatever the reason. So I'll adjourn it to November 7th, 2025 at 1 p.m. Now I'll tell both of you this, and maybe communicate with each other. If everything's all set, you've done the inspection, you've got enough to cover the back rent, and you guys would be satisfied in just taking that being done. They've moved out, everything's all set. I don't need you folks to appear here because then I can just dismiss the case. You wouldn't get a money judgment anyway. You'd be satisfied, everything be set. Fair enough?
Yeah, my biggest concern, Your Honor, is having my son, having a judgment placed against him. He's moved out of the house several months ago. And
Okay, no.
quite frankly, isn't a party to this whole situation that we're in now.
Your son, Aaron?
Yeah.
Okay, and so I'm not going to issue any judgment. If everything's taken care of, everybody's out, the security deposit gets covered. If there's a shortfall in any way, you guys work it out. If there's not, then get that portion returned. Then everybody
We're good.
okay?
Works for me.
All righty. Thank you, guys.
Thank you, Your Honor.
Thank you, Your Honor.
Take care. David Sawolski versus Lisa Laro. Lisa Laro. And what about Maria?
She's there.
Okay. Your name, sir?
David Allen Sawolski, sir.
Okay. And there was supposed to be a written answer filed. How much is a non-payment of rent case? How much is, you did file it?
I wanted, sorry. I wanted a 1.5 month, $2,400 security deposit. And, now she owes $3,200 in, back rent because, I took over. What happened, sir, was I took over the property on September 26th. I bought it.
Okay, yes, I recall.
And so, for her to stay there, I would want $1,600 per month. But that started on September 26th.
What was it before?
That was between her and the previous landlord.
So at what point did you give her notice that was now her monthly rent?
Same date.
In writing?
No, sir. I knocked on the door and she answered it and I told her that I want rent if she was willing to
On
pay.
what date did you do that?
September 26th.
And so then you were gonna charge 1,600 for October?
Yes, sir. If she
Why-
paid
Then
it,
let me just ask you this. Why do you think you would not have to give her 30 days notice at minimum before you change any condition of her rental circumstance?
I'm not sure about that, sir.
Yeah, I can tell.
Yeah.
So,
We had no agreement.
Your Honor, he came to my door and my daughter was there. Both of my daughters were there when he offered me the agreement and said he liked my dog. He said that he did not want to bother me for a down payment and that he would honor the $1,200 a month.
did you
I
tell her that?
24
No,
hours
sir.
to think about it, and I called him back and said,
Hold on a minute. Okay, but
No, sir.
so what are you claiming she owes?
Well, for her to stay there, I wanted,
No.
okay,
You filed this as a non-payment of rent case, saying
Yes.
that she hasn't paid rent.
yes, sir.
And in that complaint,
Yep,
you basically indicated that, first of all, your complaint doesn't say anything about how much she owes at all. That's blank. Then you're saying that the rental rate is $1,600 per month. What I'm hearing is that is not true.
I originally offered her, sir, 1,200 if she paid me that same day.
Okay. Your complaint indicates there's nothing about a $1,200 offer. I don't know what this whole offer thing was, and I'm not necessarily, at least at this point, going to get into it. But there was no agreement between the parties. And assuming she's, say, a tenant at will, or that you would change a condition of her tenancy, that you gave her properly 30 days notice to up her rent, yet you filed a complaint that says that the rental rate is $1,600. Frankly, sir, that's false.
Okay,
Then you don't say, you say no rent is due, right?
which item is that, sir?
Pardon?
Which item would that be on the complaint?
Look on your complaint, paragraph 5, C and D.
Yeah,
There's nothing.
yes, sir, I overlooked that, I'm sorry.
Then, so if, as you're indicating, you purchased the premises, if she were a tenant there, what happened to her previous security deposit?
I don't know that I have no idea. I have no idea if she paid one.
I did pay one. That's what I feel.
Well, hold on. Just hold on, ma'am. Just
What
take a breath, please. All right. How much did you pay as a security deposit?
Was 2,400.
Thank you. So if you purchased the premises, you would have had, she was still in the unit. That means you purchased it subject to, I'll put it in legal terms, her leasehold estate. You then become her landlord, which means that then you are the one that is responsible for the holding of her security deposit. So where's her security deposit?
I have no idea. The previous landlord told me she hadn't paid for 13 months.
That was a,
I'm sorry.
And he told me he had no.
I don't-
security deposit.
I don't care what the previous landlord said.
Yeah.
But if you took subject to a leasehold estate, you would be required to figure out, I've got a tenant in there, have they paid a security deposit? Because then you're the one that would retain it, or he's got to return it to her. But I don't know how you ask her for another security deposit, because here's what would end up happening. Presumably, you've taken that $2,400 security deposit. that security deposit that is she previously paid, and any security deposit the tenant paid, is never the landlord's money. It belongs to the tenant. Which means that if, as you want in this complaint, for her to pay another $2,400, that means she would have theoretically a $4,800 security deposit. Even if I were to permit you to have the $1,600 rental rate, which I don't think can be imposed, you would only be able, 16 plus 8 is what, 24? The maximum amount of her security deposit could be 24, which means that you would be charging her twice the amount of a security deposit that legally you could require that she pay, which is going to subject you to damages. Be honest with you, I think you bought this property without fully thinking through what you needed to do. You can't force this woman to do certain things and just automatically like appear at her door and claim that your rent has gone up by a third.
Yes, sir.
On my say-so.
Yes, sir.
Where in the heck does the $4,000 come from that you're saying that she owed? Oh, that's the $1,600 that you're claiming, which is the improper rent plus the improper security deposit.
Yes, sir.
That's where they comes up in the notice to quit?
Yes, sir. I wanted the 1.5 month security deposit plus the $1,600
You
a
need to
month.
go to the previous owner and find out where her money is. Because you're supposed to be the one now that's taking over a leasehold estate. You're the one that's supposed to retain it. And you're supposed to give her a notice of where you're retaining it.
Is she required, sir, to provide proof that she gave a security deposit to the previous landlord?
Yeah, I have my.
Hold on. You are requiring her to do some things and shifting the burden to her. I will call upon her to provide proof when it's necessary to provide proof, but I don't see anything in the beginning of this that you did that's right. At all. Have you asked the previous landlord if he has her security deposit?
I did not, sir.
See? And so now what you want me to do is ask her whether or not she paid it. Quite frankly, I'm going to say this to you. Not sure what she wants to do. But what's going to end up happening is both you and the previous landlord are end up getting sued. So my question becomes, what do you want to do with this case?
Well, if she paid a security deposit to the previous landlord, and it looks like the security deposit I asked for is no good.
Well, but where is her money? The security deposit, did you hear what I said?
Yes, sir.
The security deposit belongs to the tenant and is to be held by the landlord, but it's her money.
Yeah.
So somebody needs to find it.
Okay. So I would need to contact the previous owner and see.
I don't know what you would need to do. All I'm telling you is somebody needs to find out where her money is.
I'll contact.
Moreover, the complaint, while you certainly could amend the complaint, the one thing you cannot amend is the notice that you sent to her. That notice has numbers in it that make no sense based upon what I've just told you. However, you did file a notice that on its face looks valid, so I can't necessarily dismiss this case on subject matter jurisdiction. However, if you wish to proceed with this, you need to understand that at the very end of the complaint, and pursuant to the court rules, that you're signing that complaint under penalty of perjury. That information has to be true. I don't think that any of this is true.
Okay.
So you can make your decision as to whether or not you want to proceed with this case or not.
Well, I think it might be better to dismiss it and pursue possession.
Well, because she asserted her rights?
Well, because if she
I
put
mean,
it,
sir, get what you did.
Yeah.
You went to this woman, told her, based upon some representation that somebody else made about whether she's paid rent, not knowing the circumstances, not sure that was any of your business, but that okay, you took the place, didn't get her security deposit, asked her for an.
What you're about to hear is not a routine court appearance. Prosecutors are presenting allegations that reach far beyond a single arrest, claiming this defendant was involved in a large-scale drug operation that stretched across state lines and even involved international shipments. According to the allegations discussed in court, investigators spent years building this case before finally bringing these charges forward. The court is now hearing claims involving massive quantities of narcotics, intercepted packages, and a defendant who allegedly continued facing legal trouble even after becoming the subject of an earlier investigation. But this hearing isn't about determining guilt or innocence. The immediate question is whether the defendant can be trusted to remain free while the case moves through the court system. Prosecutors argue that the allegations, combined with other pending legal matters, show a pattern that makes him both a danger to the community and a potential flight risk. Defense counsel sees things differently and points to the defendant's history of appearing in court. As the judge weighs these competing arguments, the decision could dramatically impact what happens next.
thank you, sir.
Have a good day, ma'am.
1 p.m., November 7th.
1 p.m., November 7th.
Thank you.
Pleasant Lake Park versus Christopher Denoway.
Good afternoon, Judge. David Morris on behalf of Plaintiff Pleasant Lake Park, LLC.
Your name, sir?
Christopher Genoviak.
Okay.
Sorry about that. I'm a little hurt today. I had to step out of the hall. I'm a recipient of SSDI at 100% since March of 2020. I just got some things I want to read. I don't know how protocol is around here, but I'm sure you'll tell me.
Well, it doesn't start with that.
Just start with this.
No, it doesn't.
I didn't hear you. I'm sorry.
It does not start that way.
Okay. All right, cool. Thanks for your time.
Judge, this is our second hearing on a non-payment of rent matter. Current rent to retain possession is $495 with fees of $75, costs of $110 for a total amount of $680. We have had some discussions, but no payments have been made, and parties were unsuccessful in finding settlement. I should note, Your Honor, that it appears an answer was filed with the court, but I did not receive a copy.
We'll get your copy.
Thank you.
All right, sir, what did you want to tell me?
Okay. So they're not doing maintenance to force the default. I've spoken with an attorney, like one of those free attorneys that you call the number they give you on the form. I called one of them. They're like, yeah, you have like a brilliant retaliatory defense. I guess he's trying to do default and to quit. I guess I got the notice.
Do what?
I guess I'll just read what I have. I'll read what I have.
Well, let's not.
I don't want to jump the gun here, but I did. This kind of makes more sense. So they're not doing maintenance to force the default. They did not board up holes, but they set traps and they put poison outside the unit. Like when they should have just boarded up the holes. This creature, it's like a rodent. It's like nesting underneath my bedroom, like my bedroom floor. The skirting was never fully pulled back when he promised me that. We both saw this creature and he set traps that were too small. And then he put poison outside the unit. He never pulled the skirting back to put poison on its nest. There are multiple entries around this unit. Please, let me continue. I'm really sorry for wasting your time. We really shouldn't be here.
Ma'am,
so the skirting,
sir, you're not wasting my time. I'm getting paid.
Yes.
Go ahead.
Yes, sir. Well, I'm unemployed. I lost my job like a few weeks ago.
Okay, go ahead with your, go ahead.
I know.
Go ahead with your reading, please.
So the traps are too small. And Mr. Weasel, that's the name. That's the person trying to evict me right now. It's Mr. Weasel. Mr. Weasel and I both saw this rodent or creature, not at the same time, but it entered out of the lake. My rental unit is up against a small wooded line about 15 to 20 yards, and then there's a massive lake. So we both seen this creature. It is fat. It is large. It's like a gopher. It's like a beaver rodent creature. So there's 10 points. There's 10 points. Almost done. So the traps were too small. He put, and we both saw it. We both know it's big. So I was trying to do walkarounds, Mr. Weasel usually just sends his maintenance dude just to do the maintenance. And this maintenance gentleman is a kind man. He also lives in the park. And this gentleman also works for Mr. Weasel at the landscaping company. And let me point, for Mr. Weasel to send out this maintenance dude, he has to pay him double time. So he's a maintenance man is an employee twice for Mr. Weasel. So we did schedule one walk around, but I was late returning from cleaning up a church festival. I spent 9 hours at a church festival on Monday morning. I was cleaning. We had
So if they get rid of this animal, then
Yes, sir.
we're
Yes, sir.
all good.
We're all good. And let me just I have a couple more points. I know this is really going into banana
Do
town.
you know anything about the animal?
I did set up a trail cam. Okay,
sir.
But I don't want to use that. I just need to finish my points. So he never contacted me. He was on the property twice doing maintenance that wasn't completed, and he never contacted me when I was in the house.
Sir, I'm going to stop you.
I know. I'm sorry. I'm
going to stop you. That means stop talking.
Yes, Judge. Sorry.
Counsel, do you know anything about this animal?
We know of the idea of the animal.
Okay, I have no idea what that means.
We've heard of the issue, but my client has not set eyes on any animal. The animal at one time maybe was a mouse, and then a rat, and a cat, and then a beaver, and a badger. And so my client knows nothing about any real animal. Traps were set, the skirt was tightened on the manufactured home. He has been out, or his management has been out on multiple occasions and has responded to all legitimate requests. The defendant.
Sir, you need to turn around and face the front and not wander.
I understand the defendant set up trail cams. We've received no footage. We've received no recording. We've received no audio file, no video. The defendant claimed over the phone that there's hours of critter noise every night. There are neighbors to the defendant.
Okay, let me just stop you for a moment. Might it behoove your client to just
board up the holes that are super obvious? I'm sorry.
I don't know at what point I said I needed help with my sentence.
I know. I'm sorry.
Then you need to sit down and be quiet. Be quiet then if you can't sit.
Yes, Judge. Yes, Judge. We're cool.
Stand still.
Yeah, stand still. I know. I just gotta keep moving. I gotta keep moving sometimes. Sorry. I know. I'm sorry. I'm really sorry.
Might it behoove your client to just hire a company to come out and look and make a determination based upon evidence that they see as to whether or not this creature exists or not? Because quite frankly, if there's a company that goes out and they tell me, yes, there's an animal, then they can tell you how to eradicate it. If they say there's not an animal, we're going to be at a point that there's not an animal. And apparently not one that grows from a mouse to a beaver in no time at all. I've never heard of one in Michigan, but we'll see. All right. So how long, do you think your client would be interested in doing that, counsel?
Yes, Judge. I think my client would be happy to get an extermination company to come and write a report.
Yes. How long do you think it would take him to do that? Because I can put this over to the 7th or 14th. What would you? And I'm going to order escrow. So.
Thank you, Judge. I think the 14th would be
a better thing.
Better. What does that mean? What does order escrow?
So I'll explain that in a moment.
Sorry.
I'm going to adjourn this to November 14th, 2025 at
2 p.m.
At 2 p.m. That will be an in-person hearing. How much is monthly rent?
Monthly rent is $1,250, Your Honor.
But portion of it is paid.
Correct.
What's his portion? Do you have Section 8 or something like that, sir?
Just SSDI.
So you pay your full rent?
Yeah, I've got, I'm not employed now because of the noises underneath my bed. every night for 3.5 months. Like I can't sleep. I can't sleep
Okay,
at all.
your monthly rent is how much?
$12.50, Judge.
$12.50. All right, I'm going to order escrow in the amount of $1,250. That is.
Sometimes a courtroom hearing lasts only a few minutes, but the consequences can change someone's life forever. In this case, Reginald Tyrone Green stood before Judge Stephanie Boyd facing a critical decision after admitting to violating the terms of his probation. Just weeks after receiving deferred adjudication for unauthorized use of a vehicle, Green found himself back in court because of a new theft offense. What had started as a second chance was now at risk of becoming a state jail sentence. As the hearing unfolds, the court examines not only the new violation but also Green's overall conduct while on supervision. The judge repeatedly focuses on one central question: what did the defendant do with the opportunity he had been given? According to the discussion in court, Green had not completed significant probation requirements before new criminal allegations emerged. That fact appears to weigh heavily on the court's decision-making process. The defense attempts to provide context for Green's situation. His attorney explains that Green has struggled with mental health issues and hopes to reconnect with family members who are willing to help him rebuild his life. The goal, according to the defense, is accountability combined with treatment and support. But Judge Boyd makes it clear that the court must evaluate actions, not simply intentions. The most emotional moment arrives when Green's father takes the stand. Speaking on behalf of his son, he describes family struggles, employment difficulties, and concerns about Green's mental health. He tells the court that his son is a hardworking father who has experienced significant personal challenges and that family members are prepared to support him if given another opportunity. Despite the heartfelt testimony, Judge Boyd explains that the court cannot ignore the pattern presented in the record. A defendant who receives probation is expected to comply with its conditions. Instead, the court sees allegations of additional theft-related conduct occurring shortly after supervision began. From the judge's perspective, that pattern raises serious concerns about accountability and compliance. Ultimately, Judge Boyd revokes Green's probation, adjudicates him guilty of the original offense, and sentences him to 14 months in a state jail facility. However, the judge also leaves a small door open, stating that documented proof of mental health treatment and a structured family support plan could potentially be presented for future consideration if proper legal procedures are followed. This hearing serves as a powerful reminder that probation is often viewed as a second chance, but courts expect that opportunity to be taken seriously. When new violations occur, judges must balance compassion, rehabilitation, public safety, and personal responsibility when determining an appropriate outcome. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.